Richard Hartman versus Hartman, that's 1501 FL 631-288. Let's swear in the parties again.
Can I have you both please stand and raise your right hand? Do you solemnly state the testimony you'll give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay.
And if you want to resume the stand. And while she's doing that, for the record, I've received and reviewed a respondent's trial brief that was filed with the court as of today's date.
Yeah, it's on the issue of fiduciary duty associated with the interspousal transfer deed.
Okay. Ma'am, you're still under oath, or you're just sworn under oath, and we're on to cross, as I recall.
Well, I had a couple of questions I wanted to revisit on the interspousal transfer deed, if I could, please.
Okay, and then we'll go back to cross.
I just object. I mean, he's already rested his.
He has the right to react.
He has the right to what?
He has the right to open up direct examination.
He has the right to reopen up direct examination after he's rested?
I haven't
If it's only a few questions, but the questioning hasn't ended. It's going to be, these questions are going to be asked at the end of your question.
Right.
So I'm just doing them now, so you'll have a question.
But I mean, I've
I'm
already.
not going through this.
Okay, I'm just want to put it on the record that I've already started my cross, and then he's jumping back in.
Mr. Kilpatrick.
Also, Your Honor, you said this is a trial brief that is amended to something. What is it?
It has to do with the breach of fiduciary duty in connection with the interspousal transfer.
And this is being produced right now in the middle of a cross-examination of a witness?
It's a statement of the law. That's all it is, sir.
It's a fairly common practice amongst that attorneys have to produce briefs on relevant issues to a trial. I don't know if I would have called it a trial brief, but that's
More of a hearing brief.
It's more.
But doesn't it have to be produced prior to trial?
No. If you were to come in with a brief, I would consider it as well. Ask your questions, Mr.
Yes, may we have, I believe it's petitioner's number 3, the interspousal transfer deed.
Yes, it's not in evidence, but actually.
I think it is. It's a certified
Number two
Is
is.
it number 2 then? Yes.
Yeah.
It's not in evidence yet, I don't believe.
It is. in
Number
evidence.
two is number one is in evidence, which was one deed, and then number 2 was the interspousal transfer deed.
How is it submitted in evidence?
You asked for it to be put in evidence. Mr. Kilpatrick didn't object. I put in evidence.
Okay. Making it clear.
Did you want to see yourself?
No, I know what it is. I've already done it. Ms. Hartman, there's an interspousal transfer deed that bears your signature in connection with the Cedar Lane property. Is that correct?
Correct.
And would you look on the signature page?
Yes.
And is that your signature?
Yes.
Do you recall signing that document?
I don't remember, no.
Did you ever, did anybody disclose to you what the consequences of signing that document?
No.
Did Mr. Hartman provided you any written disclosure that signing this document may result in you not having an interest in the house?
No.
Isn't it true that that was signed because your credit score was much lower than his?
I don't know.
And it states in that deed for valuable consideration, received what is hereby acknowledged. You signed it in the house. Did you receive any valuable consideration in connection with that deed? Did Mr. Hartman pay you any money?
No.
Did he give you any property?
No.
Did he give you anything about it? Did he give you inventory?
Do you think it's
Yes. Money, property, anything at all? You saying for your signature on that deed?
no.
That's it.
You're welcome to ask questions about that as well.
Okay.
Resume your comments.
Sure, since it's already out there. Yeah. Let's see. You still have that, the copy of that in front of you?
You will in a
No.
moment.
You have it? Okay. Can you you say you don't remember signing this document?
I don't.
Okay. Can you read the date above your signature there? What, on the front page?
June 17, 2024.
2024, okay. So, and that was around the time we were purchasing Sear, correct?
Yes.
Okay. because we purchased Seeger in July of 2004. You say that you don't remember signing it, but can you, if you look on there on the top there where it describes the what the document is that you signed here, right there. Would you mind reading that first top part there?
Document speaks for itself.
I'd like to have it on the record.
Okay, go ahead and read it.
Interspousal transfer grant deed.
And the paragraph there below it.
I undersign grantors declares documentary transfer, tax non-city transfer, tax non. This conveyance is only between spouses and the spouse establishes the sole and separate property of a house and
Spouse.
is exempt. Spouse and is exempt from the imposition of the documentary transfer tax pursuit. Revenue and taxation code.
Okay, and then the next paragraph there.
This is an interspousal transfer and not a change in ownership under section 63 of the Revenue and Taxation Code. And transfer by grantors is excluded from reappraisal as a creation transfer solely between the spouses of any co-owner's interest.
Okay, and the next one.
For a valuable consideration receipt of which is hereby acknowledged.
And the next one.
Your Honor, this is in evidence, it's wasting time.
It's in evidence, but she didn't understand what it was signing. But it is clear, it is plain text here, what it is. I'm having her read it to be on the record.
Ma'am, you can read it to yourself in class if you.
Okay,
But
go ahead.
it's in evidence. We already have that she signed the document.
She signed the document. She didn't know what she was signing. He's saying that she was under undue influence and that she didn't receive anything for it. And I'm getting to the point, I'm on the record of what is actually in clear, plain text, what it says and what it means.
I don't dispute what it says.
Well, I want her to, if she doesn't understand what it means,
If he is willing to acknowledge that she didn't understand this.
I'm not going to acknowledge that.
You can ask questions. I'm not going to let you go through.
Okay,
reading it.
let her read it, and I'll question her. Okay, and at the time we were buying Seeger, right?
Yes.
Okay. Do you know how much the price was for Seeger that we paid for it?
$200. I don't.
Mm-hmm,
recall.
200,000. And at that time, do you recall what our income was at that time, and we were buying this home?
It's irrelevant.
Sustained.
How is it sustained like that? I mean, it's relevant in the fact that it proves that the reason for the signing of this and the purchase of the property go hand in hand together. Without one, it's not the other. I couldn't have bought the home without the other. I had to use it, my separate property, to purchase this property, and it goes hand in hand. How is it not relevant?
I'm sustaining the objection. Next
Okay.
question.
Next question is, would we be able to afford would we have been able to buy Seeger without the my separate property being put down payment for that house?
Objection, it's irrelevant, there was no separate property.
Well,
There's no separate property again?
There's no separate property in Seeger.
Wow.
The other question. Stop. Question you asked on direct examination. You asked a question along the lines of, did you did you sign that because your credit score is bad, which I
Correct.
think opens the door to questions about the reasoning why she signed it.
Very well,
That's why I'm going to allow the question.
no worries.
Go ahead and ask the question.
Would we be able to buy Seeger if we hadn't sold my property on Sandra?
I'm not sure.
Not sure. Do you remember what our payment was on Seeger?
It's irrelevant.
What's the relevance to your?
The reference says we couldn't afford it. We couldn't afford to buy it without using my separate property.
That's a misstatement of the facts. There was no separate property that went into Seeger.
I don't understand how you can say there's no separate property when I have grant deeds that says I am the sole and this intertransfer specifically says it's my sole and separate. She even says as it's my sole and separate property with no interest. It's in the tax code even.
Go ahead, and did you read the brief?
No, I haven't had a chance. I sat down.
Go
You
ahead.
gonna give me a chance to read it? What is this here? Okay, so what I'm understanding, this is Mr. Kilpatrick's opinion on this? Or did she sign this? I don't see her signature on this paper at all, but this is his opinion?
This is his brief on the
His
issue
brief.
of law.
Right, but what does he have to do with my property? Where's her declaration of
I'm
this?
going to object to this. We've been in this hearing for days, and it goes on and on and on because Mr. Hartman will not exercise appropriate courtroom decorum.
Well, I'm gonna make one thing I should have said at the outset, I'm ending this today at 4:30. I don't care if you get to your Epstein credits or not, I'm ending at 4:30. So if you want the time to get to the Epstein credits, then I suggest that you move along.
Okay, I'm moving along. What is this that's laying here, does it mean? Does he mean did he admit this or he submitted it or what is it?
It's a brief that any counsel can give to a judge to explain their position on the law,
Okay.
and that's what it is.
So it's up to me. Okay, so to prove the burden that there was no undue burden, and I took advantage, right? It's up to me to prove that, right?
Yes, or that you did not take advantage of her.
Right. I have to prove I didn't take advantage of her, right?
Yes,
Okay. We were buying a home, correct? Together.
Correct.
Did both of our names go onto that home deed, the grant deed together? You don't know.
I don't know if it's on there. I haven't seen the grant deed.
So you don't know if you have any ownership or what in Seeger?
Yes, I do.
Oh, you do know. So was our names on both the deeds? On the deed there for Seeger?
Yes.
Okay, so when I sold Sandra and we were buying Seeger, I wasn't saying that you need to sign this because I'm gonna get this money later on down the road, and I'm going to also put my name solely on the property we're buying, right? I didn't take claim of the property solely in my name, did I?
Objection. The question is unintelligible.
sustained.
Did I take possession of Seeger in my name only when we bought it?
No.
It says both of our names was on the deed.
Yes.
So there was no advantage to me as far as property goes, right?
I don't understand.
there's no advantage to me as far as, my name is not just solely on the property, right?
Correct.
Did you make any payments, to Sandra?
Objection is irrelevant. They were married for 3 years prior to its sale. You made payments. That's her money.
Do you understand that the money that you made during the marriage was community property?
I also have the Morris Marsden calculation for that also, and the percentage of that. So,
So are you done asking your question so you can move on to the more Marsden issue?
well, I mean, he's talking about, he's bringing that factor up about how, I took advantage and that there's no, 'cause it's community property now, that because she was with me for 3 years. And so that he's bringing up the issue of the more Marsden, when a person owns a property prior to marriage and there's some community property that helps pay down the mortgage, it immediately falls under that. There's 4 steps to the more Marsden. And there's a formula that kicks down. I should not be, this is all factual matters that
I'm going to object to this. This is not time for argument.
I'm not arguing.
That's why I asked if you're done with asking your questions. Now is the time to ask her questions.
Okay. I've been asking her questions.
Ask the next question.
There was no advantage, when we bought Seeger, my name is on the deed as well as yours, right?
Ask and answer.
Right. So if we if we were to sell it at any time, even now, we're on there. We both would get a profit from that, right?
Right.
Right. And if I hadn't put my property down as a down payment, do you know what the payment would have been?
No.
It would have been $1,800 a month.
Another question.
You can't testify. You're testifying.
I'm not testifying, but I can.
You just said was going to be 18.
See the cross examination. I can lead.
But you weren't leading. You were testifying. Next question.
Do you remember the amount of the mortgage? What it would have been if we didn't put down the money from the separate property?
Objection. It's not separate property.
Hasn't been characterized as separate property yet. Next, if you want to refer to it as the money from the Sandra property, then that's fine. But it's not been characterized as separate property at this point.
I'd like to have her take a look at another. I have another document I'd like to have her take a look at.
Is it being marked or is it going straight?
It needs to be marked.
We need to mark it first.
I have a 2-page document that's marked petitioner's number 7.
Can you tell us what the title under there? What the document you're reading says?
Grant deed.
Okay. Can you read there when it says for a valuable consideration? After that, can you read that? Where it starts with my name?
For a valuable consideration, receipt of which is hereby acknowledged, Dwayne T. Hartman, a married man, as his sole and separate property, who acquired title as Dwayne T. Hartman, a single man.
So it's stating that at this time I'm a married man, but this is talking about my separate property, correct?
Objection calls for legal conclusion.
Well, let me see the document. How would she know this recitation in this deed is signed by you? So how would she be familiar with be familiar with the,
Well, she worked at R&M Tire Service. It was a family company for years, and she did the books and the payroll, and she signed the checks, and she also knows my signature because I've signed numerous documents with her every day for years. So she would know my signature, and she would know. I mean, she knows.
but how would she, but she's not the one that said it was your sole and separate property, correct?
Yes, she did say that.
In that deed?
She said it in an intertransfer spousal deed along with this on the same date as this was written and signed.
Okay, Mr. Kilpatrick, is number 7, it's certified, and
It is, it should be, I want to object to its admissibility.
it's an evidence. 7 is evidence.
Thank you. There's a signature on the bottom. Is there just one signature on the bottom of this document?
Yes,
And whose signature is that?
yours.
Okay. There's a reason this is one signature. This is a grant deed of Sandra that's granting it to the sale of the people that bought the property from me. Do you understand that?
Calls for legal conclusion.
Sustained.
Okay. Let's move on here. We can move on from the interspousal now if you like. Is that okay?
Would like to go ahead and ask the next question.
All right. When you moved out, packed up, and you moved out of the house on Seeger, did you make any payments, to the property taxes or, mortgage or upkeep to the mobile home on 4309 Estate Street?
No.
It's a compound question.
I've been allowed, and
Okay. I'd like to take a look at another document.
set them on the same date as the, yeah.
I have a 3-page document marked as petitioners number 8.
Can you read the top of that page of that document and tell me for the court?
Objection, it's hearsay. Lacks foundation. It's not a certified copy of anything.
It's personal knowledge. I mean, this is for.
I can read a hearsay document.
I've never heard a hearsay document.
I've been reviewing it for purposes of visibility only. Yeah. Had she signed it? Do you have a signed version where she signed this?
I think so.
But at that, I'm sustaining the objection, that is hearsay. If it's an adopted admission and with her signature on it, then it would be a different story.
I can lay the foundation for it then because it's from our, sale of our property. It's from our document from escrow.
You legally cannot lay that foundation. It has to be a representative of Chicago Tire.
I'm sustaining the hearsay objection. Next question.
I mean, I can't offer up. We can't have proof from our own files, our own personal files, checks or printed receipts or
Jack, Mr. Hartman does not have the right to make inquiry of the court.
making what?
I'm not going to answer that question. Next question.
Okay. Do you remember what we sold the mobile home for?
I don't recall.
You don't recall? I mean, right in front of you. you know. Sell a property.
$97,500.
Right. And do you remember what the payment was for the mobile home?
Zero.
It's relevant in the fact that she hasn't made a payment since she left in 2015. I've been making all the payments. I pulled it, the maintenance,
I object to
the
speaking
taxes.
objections.
She's
Sustained.
okay. She's liable for half the marital bills. She's the property taxes, the maintenance, upkeep, the mortgage. She's half of that is her bill.
5-minute recess.
They gotta play the game.
Mr. Hartman,
Argue the what?
what do you believe the result should be in the case?
Well, Your Honor, I mean, the result in the case is that I've been maintaining the marital asset bill since 2015 on my own. I filed for divorce January 2000, and I did it without an attorney. I didn't ask for anything but 50-50 with my children. I don't have a record. I didn't have a past history of domestic violence. Nothing. Our bills, we didn't have the issues like that in our marriage. There was a breakdown. I filed for divorce civilly. Since then, I've been having to endure many battles, attacks, and I've not been able to have any day in court to be heard. I haven't, every ex parte, there's not been a police report. There's not been any offer of proof or evidence. It's always been just an allegation, a statement made. That's it. And I've raised my kids. I've paid my bills. I never try to take anything from her. And I've been going through this now almost 8 years. And I've been trying to offer up the facts for 8 years, the opportunity. I did not get discovery. You said you put a hearing together out of the blue. You guys called me up. You're going to have a hearing. Then you postponed it. Then you continued it for 6 months. I've never heard anything like that. After 6 months, I think you have to repetition for a divorce. I mean, it's in the book under the family code that, after it's got to be done in a timely manner. I've been asking for this every time I've been to court. I've been bringing up this issue, and Mr. Komatrick is the one always having to speak up and tries to say something that makes the law, and he's been incorrect every time. And that the code's in the book, everything is in there. I don't understand why is it got to be this difficult? I don't understand. As far as me being a pro se, the Supreme Court even ruled under Haynes and Kremner that I should have the opportunity to offer proof. And I haven't been able to do that. I'm being blocked every way. I don't understand it. I don't know what's going on with the record, but I hope that this is about being on the record. Because this ain't right. He's got the money from my funds, from the 85.5, which is my separate property, which I had ordered to put into an account in 7 days from Judge Gill, and he's got the proceeds from my mobile home sale of $50,000 in a trust account that he took my name off illegally. He took my name off of a trust of property that I put into an account. And being that yesterday he made a statement saying he did not know the whereabouts of the money of the proceeds of my mobile home, we need to look into a forensic analysis of find out what's going on with that account. He should know. He is the custodian of that trust. I mean, it's very important that if someone's going to be a manager of a trust fund, that they should know where the whereabouts of the proceeds are. And yesterday he made a statement in court saying that he did not know any whereabouts or where they were or nothing about it. So I don't know what he's done with it. I don't know why he would not know. He has plenty of time to bring all that information here to court. But it seems like he's trying to block that information from being heard. So, I hope I'm out under, whatever rulings you decide to make, I hope you make them under findings of facts, and you put in there what the reason for what it is. Because, I'm trying to make this, preserve this record about what's going on here, and something ain't right. And for some reason, I'm just being attacked. Even when she admits that she didn't tell the truth in her ex parte, I'm still being attacked. So I don't know what's going on. If someone is admitting on a stand that they haven't told the truth, and all these results are because of this, and it's been like this ever since, there's a pattern of abuse here. There's unclean hands. There's fraud on the court. I brought it up. And, I don't understand why nothing's being done about it. I'm bringing it to your attention. Under the color of law, my rights need to be protected. I maybe don't feel that way. I don't understand what it is, but I just feel like every angle, every block, I'm being blocked for no reason. And, and from what it is, I've not lied. I have not made up anything. I have the facts to prove what I'm saying. So, what's right is he needs to be investigated as far as these IOTA accounts in Wells Fargo, where that money's at. A ledger needs to be put out. I'm asking that a ledger needs to be put out, showing when it was deposited in there and how it was maintained for the time that he's had that money. And I'm that should be to my knowledge of what that is. Because if he comes in here and says he doesn't know where the whereabouts of that money is or that sale of the property, then there's a problem. There's an accountability problem there. So I don't know if I'm speaking on deaf ears here or not, but I'm asking for the court to look into this, and I'm asking also that these property taxes, I've been paying them every year. I have the proof. I can get the proof. The court's not even willing to give me evidence to show it. You're putting demands on me. I can't have one more question on my direct, or I can't have one question on my redirect. I'm not allowed to offer the proof. I'm not allowed to even get the proof. You're not even giving me the opportunity. You're saying that I've had all this time, but you got court 6 months ago, and then you moved me in. You continued it out 6 more months. I've never heard anything like that before. I never heard something being continued out 6 months, and then all of a sudden there's no discovery. And I've came to the trial settlement conferences, status conferences, and every time I've sat down here, nobody wants to speak about what's going to happen about the trial. They just want to talk about, this is the date, we're going to come back in here and do this. That's not right. And I wanted to be on the record for that.
Mr. Kilpatrick.
Yes, thank you, Your Honor. First, as far as custody visitation, I believe Mr. Hartman has proved my case. He clearly has emotional problems. He has not seen his children since December of 2019. And this is the reason, and the court may glean this in taking judicial notice of its file. We appeared on December.
Objection, Your Honor. This isn't the time to submit documents and evidence. This is not the argument time, or this isn't the evidence time. And all of a sudden now he's pulling out his book and he's trying to submit documents.
I said I'd take judicial notice of the
I
file.
would invite you to take judicial notice.
Of the whole file?
That's what I said.
Of December 9, 2019 by the Honorable Don Biddleston. There was an ex parte hearing. The court made the following findings and orders. Both parties shall submit to a urine drug test at National Toxicology Laboratory before noon today. Each party.
Objection, Your Honor. There was not even a hearing about that. That document is, that's the second document that's identical. I was not even given a copy of this document. And also the document, it says it's a false positive on there. I was not given a hearing on that, and it was not admitted into evidence. They made the orders that were prior to that were temporary orders, and I was not given a hearing on that.
And each party shall advance the cost.
I'm sorry, Mr.
Each party shall advance the cost of the test for the other. Failure to test shall be deemed a positive test. Cause continued December 10, 2019.
I object, Your Honor, because he's reading off something. He's not reading the entire document in its entirety. If he reads up there and he states what that document, the document is not even in the file. It's not been admitted or submitted rightly in there. I haven't had a chance to even have a hearing on that. It says in there that the DL inhibitor was on there, and that's basically a false positive.
And
He
the,
can't submit that.
Mr.
this is just a minute order,
Yeah, what date is the minute order? I'll just read it for myself.
very well. And when we returned the next day, the class court granted the ex-party, suspended his week on and week off, and gave him supervised visit because he tested positive for methamphetamine.
No, I did not. Objection, Your Honor. That's not true. That is a false statement, and I have the records. I have the records on this.
Courtesy of allowing you to speak, I would ask the same.
I object because he's making fact. He's testifying. This is untrue.
Mr. Kilpatrick, I'm just gonna rule at this time.
Very well.
Having heard the evidence, I'm going to make a finding. First of all, I'm making a finding that I had to terminate the hearing. I had to terminate several cross-examinations due to severe disruptions in the court procedure conducted by the petitioner. I'm granting sole legal, sole physical to mom, supervised visitation to dad, and this continuing.
I object, Your Honor.
I recognize that.
I object.
And I'm adopting the reasoning in terms of the travel trailer, because there's $7,000 of value, and I'm taking for that $7,000 of it, I'm just going, and what there's just a wash there. I don't believe that your client has the sufficient foundation as to the
Your Honor, I'm not even completely with my case. There's evidence I have that are relevant to this case, Your Honor.
I'm adopting your calculations as set forth in your respondent's trial brief, which was filed to today for the purposes of reimbursement.
I object.
Again, I recognize that. I am ordering the $97,664 in terms of Watts credits. I'm making a specific finding that he did not prove the tracing, did not prove the Moore Marsden.
He has to have Epson. He's got to prove. He's going to use Watts. He has to have the Epson's credits in there.
Okay, sir.
And he did.
At this time, the judge is making his ruling. We understand that you object to everything. It will stand. Let the judge speak.
It's all right.
And I
Right.
request that the child support continue in the same amount that was so ordered. Mr. Kilpatrick, given the nature of this case, the volume of the hearing, and under the California report, I'm allowed to ask you to create a statement of decision. And since I'm adopting the reasoning, I'm going to ask you to do that.
I would do that, it'll probably take me a couple weeks.
Yes.
Thank you. Thank you, I appreciate it.
Ultimately, Mr. Kilpatrick will need to do the judgment.
I will prepare the judgment along, I'll for a safe decision, they will prepare the judgment.
I object to all this, Your Honor.
And this is gonna be distressing to Mrs. Harper, because she don't get it.
We shall see. Come on, they got the owner. They got the owner.
What happened?
They said, fuck it, he's gonna make a ruling, but make some bullshit. They just said, fuck it.